Muslim madam,
Yes, sir.
can you read the first line for the confirmation? Special guest lecture.
S- A special guest lecture on intellectual property rights.
Yeah. Thank you, ma'am. Thank you. Yeah. Same thing. Muslim madam,
Good
congratulations for
afternoon
your
to all of
page.
you.
Yeah.
Respected Professor Shahid Ali Sir, Dean, Faculty of Humanities and Social Sciences. Respected Dr. H.M. Arif Sir, Head, Department of Languages, my fellow colleague and dear participants. I, Dr. Mursaleen Jahan, Assistant Professor in the Department of Languages, wish to extend a cordial welcome to all of you to the special online guest lectures on intellectual property rights organized by DQAC, Department of Languages, Integral University, Lucknow. Today, we have with us Dr. Lieutenant Kantilal Nagre and Dr. Dinesh Wanule, both assistant professors in the Department of Zoology at BK Birla College, Kalyan, Maharashtra, as the resource person for today's event, who will be shedding light on IPR and Patent Act 1970. On the behalf of the Department of Languages, it's an honor and privilege for me to greet and welcome you, sir. Your knowledge and expertise related to intellectual property rights will be extremely beneficial to the participants. I also wish to use this platform to share that the Department of Languages focuses on studies in literature at graduate, postgraduate, and doctoral levels. We offer BA Honors in English, MA in English Literature, and Advanced Professional Communication Skills to engineering, graduates in sciences, computer applications, agriculture, and many more. And proficiency certificate and diploma in languages like Arabic, Urdu, German, French, and Persian. And also ESP for foreign students. Integral University is a well known name in the Middle East, having a huge number of students from abroad. It is basically situated in Lucknow, city of Nawabs, and the capital of Uttar Pradesh. Coming to the point, the objective of today's guest lectures is to empower the academician, faculty members, research scholars, postgraduate students, especially those belonging to the field of arts and humanities, with the knowledge of various categories of intellectual property rights and the laws governing the defense of the rights of the patentee, with a special focus on patent law of 1970. We all are well aware of that the rights granted to individuals over the creations of the mind, such as inventions, literary and artistic works, designs, symbol, names, or images, are known as intellectual property rights. They are usually grant the inventor a time-limited exclusive rights to utilize his or her creation. A patent is one of the categories of IPR, which is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offer a new technical solution to a problem. Patents in India are currently governed by the Patent Act of 1970. With this note, now I request Dr. Amna Shamim, Assistant Professor in the Department of Languages, to welcome and introduce today's expert speaker to our virtual audience.
Dr. Mursaleen. Good afternoon, everyone. I feel extremely delighted in introducing our first speaker today in the guest lectures on IPR organized by the Department of Languages and coordinated by Dr. Mursaleen Jahan. Our first speaker today is Dr. Lieutenant Kantilal Nagre. He is Assistant Professor in the Department of Zoology at BK Birla College, Kalyan, Maharashtra. He has 28 years of work experience. His areas of specialization are endocrinology, nanobiotechnology, histology, and patenting. He has attended many conferences and presented approximately 80 oral and poster presentations. Sir has published 11 patents and has been granted with 4 patents. At present, he is in the process of drafting yet another 9 patents. Dr. Nagre has created a MOOC platform for online courses too. He has published books on population ecology and research presentation, as well as environmental degradation and management. He has also reviewed 12 books. Dr. Nagare has delivered keynote addresses in various seminars and conferences on IPR. With this, I would like to invite Dr. Lieutenant Kantilal Nagare to brief our audience about intellectual property rights. Over to you, sir.
Thank you, ma'am. Thank you. First of all, thanks to Dr. Shahid Ali sir. Just a minute. Shahid Ali sir is a Dean of Faculty of Arts at Indigarh University. Also, thanks to Dr. Mosulin Madam, who is the organizing coordinator for the Department of Languages of the Integral University. Dr. H.M. Arif Nadvi sir, who is the HOD, head of the Department of Languages, for giving me this opportunity delivering the lecture regarding the intellectual property right. Also, thanks to Amina Madam. Thanks for my introduction, Madam. Intellectual property right is a new scenario coming up. I will going to cover why the research scholars should go for IPR, and my colleague Dr. Dinesh Wanule, he will going to speak about the Patent Act of 1970. First of all, you can see on the screen the patent certificate regarding related with which already granted to me. It is granted around last year, that is 30th July 2020. I cannot tell you about my happiness, the same happiness which I got after my PhD. I got same after this certificate. Now today I am with another 15 patents. This another certificate of my patent. You can see the design number 345988-001. The date of awarding is 9th July 2021. You can see the red logo of Government of India on the red top, and then patent name is mentioned there, robotic device for teaching maths. My intention to share these two certificate in the first phone when I was talking with Muslin Madam. Madam told me Nagresar Arts Faculty College and English language students and English language researchers and postdoctoral students will be listening to the topic. Madam, I am sharing this certificate because this certificate I got for my patent in arts faculty in the geography, and this another certificate which I got for the Hindi language. I am happy to share with you that the patent in Hindi language has been granted by the Government of India for the first time. And with Dr. Grishma Khobragade, who is the English department head in our college, we are planning to apply, planning to have under process for patenting in English language. It will be the first patent which will be granted by the Government of India, it most probably uh, in the coming year. But then why the patent is needed? You know, there are IITs, there are IIM, there are language laboratories, there are Rajoga laboratories, there are various Prayogshalas, the laboratories of biotechnologies. They do research. They do research. but they don't go for industrialization of that, the production of that. The main reason is there is a dealing between industries and companies and research organization. I remember the days. I just read the newspaper that last year around 22,000 of Indian students have been awarded PhD, and of this 22,000 from the IIT, IIM, Indian Institute of Science, Bangalore, and big scientific research laboratories, around 6,000 students have been awarded PhD. And out of these 6,000, very few are in contact with industries. That is due to research. You find out something new. You go for new inventions, but then your new inventions are not that way commercialized. The reason behind that is the main reason is dealing between industries and research organization. When you have talked with the industries, they said whom we should contact, हम किसको मिलना चाहे, whom we should contact for this type of research, which biotechnology laboratory we should go, which IPR laboratory we should go, who will guide us. And then the scenario come, the answer come in front that whatever type of industry you got, go for the patenting of that particular type, and whatever laboratory having the maximum patent in that particular field, please go and link with them. And that is how the patenting name came into front for the research organization. The application of current research for the doctoral degree. In last 1 year, I attended online PhD vivas, and I found that few students of IIT Bombay in their PhD viva, in their PhD thesis, they are attaching with them the patent certificate. Madam, here having patent certificate with the PhD thesis good give weightage to the PhD thesis. The reason behind that patent itself is a new invention, and when the invention is new, it is not like the problem of plagiarism or something like copying problem. All these are already solved. Also, Modi sir, our respected Prime Minister, he always keep talking about Make in India movement. Make in India. We will produce everything in India and we will market them from the small thing till the missile technology. Why not to have everything production in India? Why to go and beg to big foreign countries? He gave the name स्वर्णिम भारत, हम बनाएंगे और बाकी बाहर बेचेंगे. That is what is स्वर्णिम भारत. Many times we science people always suffer from one question. Even the same thing is with all teachers, all PhD guides. Sir, you are giving us the degree. We are BA, we are BCom, we are BSc, we are MBI, we are PhD. But what is of this degree? What will go in the market? What we will do with this degree? And then entrepreneurship is the biggest answer for that. Madam, here I am happy to share with you. Out of my 15 patents, 12 patents are already have been sold to different companies. Madam, I would like to add one more thing that my patent in the geography and my patent in the Hindi language are also have been kept to the board for the selling purpose. And three of the company that approach us for our Hindi language patent. Hope so. This is the first day interaction between the Integral University and my department will continue. Same thing. And why not to think for within the coming years? Why not to think for such a patent which will be with English language with Integral Universities? So entrepreneurship is one of the great opportunity where the student with their patenting language go and start their own business. They can go for small scale industries, they can go for middle scale industries, or they can go for even a personal small production productive unit. Then patenting is good for the API. We all teachers always keep talking about API. We publish paper and we write books and all that. But patent API is one of the good criteria. If you have a national patent, if you have international patent, 10 odd marks are also given to you. Whenever But then what is patent? I'm going to share a lot many slides regarding the introduction of the patent because I'm going to talk about the use of the patent, introduction of the patent and use of the patent for that particular department. And then my colleague Dr. Dinesh Wanule will going to highlight about Patent Act 1970. Patent. You are already language people, you must be knowing all this dictionary meaning is the legal document that is granted to the inventor by the Patent Office Controller General of the Patent Design and Trademark. Convention application of the patent made by the virtue of section number 135. The dictionary meaning which we explain to all industries people or the technology science student. Madam, here I will be happy to share with you. In all these patent office and control general of the patent, the vacancies for language patents are vacant till today. I'm sorry to say, but this is the condition. All English literature student, all English language student are most welcome as a as a as a patent officers, freelancing patent officers or freelancing patent designer and freelancing trademarks for the purpose of drafting the patents and granting the patents. Yet today, hardly 10% of the vacancies have been filled. You can very well guide your PG student and PhD student for these good job opportunities. Patent will be granted if the satisfactory condition of the patentability is satisfied, and patentability is the missing link between the inventors and then companies. We do research, but we don't know how to go for patenting of the dat, and that is the lagging behind with all those scientific people, biotechnology people, industry people, biophysics people, biostatistics people, even chemistry people, industrial microbiology people, that they are lagging behind in patentability. And in this patentability, please, all those English language student and economic student plays a great role. Although the English language student and economics student plays a great role. I know people from economics earning lakhs per month. I know people from English language in Mumbai earning lakhs per month for converting the research, scientific research into patentability capacity. This is a good opportunity where your or English language student can concentrate more. Why to go for patents? Call of the time. समय की पुकार. समय की पुकार. I know 20 years back when all the teachers were MSCs, MCOM or PGs, the teacher with PhD was getting good respect. Yeah, good. Then the scenario came. The teacher with high impact factor publication is getting respect. Now today, the teacher with patentability and patent is getting respect. Patentability and patent, these are two different factors. The teacher with patentability can go for many such patents. There are figures kept on the board. In the China, around 15 to 16 lakhs of the patent have been granted per year. In the America, around 6 to 7 lakhs people have been patent have been granted are being granted per year. Japan, a small country like smaller than Maharashtra, smaller than Rajasthan, is granting around 3 to 4 lakhs patent per day. But what per year? Sorry, not per day, per year. But what is condition in India? Last year in India, madam, around 48 thousand applications of the patents were given to the government of India, and around 23,000 patents were granted. 23,000 patents were granted. I'm in patent field for last 10 years, and when we talk about why the number is so less, being we got big IITs, we got big IIMs, we got big Indian Institute of Sciences all over the India. We got Accelera, Jamnalal Bajaj, many such industries, many such link between companies and education institutions. Even we are with maximum universities in the world, one of the maximum universities in the world. Why the patents are very less? The we came to know the reason is we are lacking behind the patentability. who have PhD guides. A few months back, I deliver a lecture in BRC, Baba Atomic Research Center. I who deliver lectures in Tata Institute of Fundamental Research. And what we found that there are technologies, but the technologies are not drafted to the capacity or patentability and then are applied to the patent office. But good sign is there. In 2022, around 23-25,000 patents are being granted. In 2018, only 6,000 patents were being granted, and in 2014, only 4,500 patents were granted. And all these increases because of increasing capacity of patentability of Indian researcher. Please see the last line. There is a large scope in research in area in India. This large scope in not in I'll correct this statement, not only in the research but converting research into patentability is a missing link in India, and this patentability is nothing but drafting of the patent, and drafting is a good job for language people. I'm in panel with English literature people in my college. I'm in touch with Hindi literature people in my college. I'm in touch with Marathi literature people in my college, and we are giving them training that come on, your PG student should learn how to convert all this research into patentability and pass them to the industries. This is a good link, a good opportunity for language students in coming future. Patent should have novelty, patent should have non-obviousness, patent should have industrial application and in-depth practical approach. Madam, these are the criteria given in the textbook, given in the dictionaries. We here, because you told me already that the students are from PG and doctoral students from English language are there. You should find out the terminology novelty in their patent. I'm here if not if something like, because I'm talking for the first time in front of a language student. I keep talking in front of the technology student because patent is mostly with the science student. But today my view is different. If my view is how to convert patent into patentability, how to draft the patent, that is what is a need with the English literature student should learn. And novelty, with the you have to sit with the inventor, you have to keep asking the question to the inventor, take out the novelty of his invention and draft it as if he will be getting the patent. He will be getting the patent. Industrial application and in the practical approach is nothing but the technological terminology where the inventors they go for technical approach. Patent is needed because it will increase the public image of the department as well as for the institution. Yes, it is right. In my college, I got around 11 patent granted, around 8 another patent I have been published, and another 15 odd patent I am uh, working for that. But in my institution, we got 60 patents, and whenever NAC committee or any other criteria committee visits us, our director and our principals, they initially introduce them with the invention idea. Next line is improve the quality of research in the department. This is very good. The moment your students start working on the patent, his way of thinking and his way of going to the depth get drastically change. Today in my college, we all science peoples, we always involve the language student with us because language student and science student they work together, and drafting that patentability is done by English literature student, Hindi department student, Marathi department student, and then the technology is given by our biotechnology student, our bioanalytical student, our industrial chemistry student, or industrial microbiology student, and drafting and getting patent in my department has in my institution has increased around 3 to 4 fold. Increase the opportunity of research funding is a good criteria. Once the funds are also diverted to our department by our previous records of the patentability, sustain the scholarship level for all research scholars. Public benefit, you own the invention for 20 years with you. Think of the student who is doing PhD at the age of 25 to 30 and another 20 more years. His invention will keep on giving him monetary as well as social benefit. Student research scholars and guide mentor success and satisfaction is very good. I told you when I show you the certificate of the patent in the first slide. The moment I got PhD, I was happy. I worked for 6 years in PhD, and now with the patent, I work for 1 year, and I get some satisfaction when my student appear for the PhD viva, and when they show the certificate of patent to the open viva screen, lot many problems automatically get overcome because patent is given to those which are not like flagarized. Okay, national international recognition is very high. I know after starting patent in my institution, many of the students they went to the US and UK for their further postdoctoral research, and I am happy here that some of the Hindi student with the Hindi patents are now planning to go to foreign. My teacher, one of the teacher of my department who is Hindi language guide has been is being called to the Tokyo University in Japan for the same purpose because of his patentability background. So this is just beginning. I'm telling you. Then startup in Maharashtra, MIDC, Maharashtra Industrial Development Corporation, they're calling the student. They have various scheme. Same thing will be with in your state also. Uh, they give extra fund and few documents are not required if the entrepreneur is starting his small scale unit with his patent certificate. Industrial avenue, industrial consultancy, special consideration for CAS, API, PABS scheme, PG and PhD guide. These all things which we teachers keep on talking daily basis. Special consideration for the institution in AICT ranking, NAC ranking, NAC accreditation, NIRF accreditation everywhere. Same thing has helped us. My college got NAC ranking, NAC score 3.56 because of this patentability. All the departments have started their own research, and I'm happy to add you, madam. Now in my college, even the English department, Hindi department, language department, economics department, they are also started working on patentability. Teachers and researcher can go for utility patent. Of course, utility patent is required for the scientific background. Till today, sorry to say, I have very less knowledge about utility patenting in English language. But within 6 months, we'll be with English patent, and I'll be rich with the utility knowledge with the language student. So utility patent is nothing but the things which you use daily life and patenting for those. Teacher researcher should not go for improvement of the existing pattern. This happens in science. If someone find out one instrument and another teacher they go for more modification in that, and then they apply for the patenting in that, and then if the patentability lag behind, they get trapped in the plagiarism, and that is why the teachers and students should not go for improving the existing pattern, though it is faster than the for the awarding. Difficulty for the teachers facing and researchers scholar face. The first line, my invention, can I patent it? Madam, same problem was with my geography department. My geography teachers, they were with new invention. They were from last faculty, and same problem was with my Hindi department teachers. They were having research. उनके पास रिसर्च था. एक दिन वो मेरे पास आके बोल रहे कि हमने ये रिसर्च बनाया है. आप तो साइंस वाले हो, क्या आप इसका पेटेंट बना सकते हो? And then I saw it. It was totally in Hindi language. And then we sat together. We worked for 2 months, and ultimately we found that it is a patentability in Hindi language, and it was first patent in Hindi language was drafted from my institution. Procedure, don't worry about the procedure, madam. If in your college, if you're in your institution, some legal advisor is there, he's already aware of that and procedure he can follow. Otherwise, there are various private firms they guide you for the procedure of patentability. Agent threats. the great threat of the agent is there in this patent field. It is all positive and negative side. So agent should be you should have MOU with the agent, and then only you disclose your invention to the agent. Otherwise, you disclose to the agent and then you lose it because he will a lot many malpractice also happens in this field. Sorry, will not go in detail for that. Cost of filing the patent, how much I have to spend? Very less, very less. There are PG student, there are PhD student. Student, please listen. Government of India charge only 1,000 rupees for the patent from the student and teacher for the uh, learning institutions. Okay, only 1,000 rupees is very cheap, but people they don't know it, and then that is why they go for agents, and agent charge for 50,000, 20,000, something like that. Time required, if it is design pattern, hardly 2 months. If it is design pattern, hardly 2 months. Okay, type of patents, there are many types of patents. Okay, invention disclosed with whom. So these are the things which normally students they don't know, and then they get trapped with the patent agent, and patent agent squeeze them monetary. Even patent agent squeeze the PhD guide also monetary. I am a PhD guide, I am a teacher, I help all those guides free of cost hereafter, because you are Muslim madam student, you are student of Arif sir, you are student of Shahid Ali sir, have my number. If you got any invention in English language, please communicate with me. Please give me sufficient time because I am from scientific background. Let me go through it. I can help you to patent your invention at least 60 to 70%. Rest all your subject expert will guide you. Terms and publish. See, literary, dramatic, musical, artistic work, they are granted to the art student for life of the author, plus 60 years. Cinematography, film and sound recording, 60 years from the date of publication. In this time of Corona holidays, the Doordarshan started the old serials, Ramayana, Mahabharata, and all that, and they were again have to give their charges to the producer. The reason behind that because they are patented long back. So 60 years stuck, you can keep on earning money on that basis. For arts faculty research, discovery, finding a new thing, property of known material or article can be go for the patentability. Invention, a new product or process. This slide I share with you. The reason behind that, you people, you are already with the English background. You are very good for converting the scientific patent to the patent by the patentability to the patent awarding till the patent get awarded. And these terms you should know, because when you approach to the scientific people, you will be helping for them the patentability aspect. Documents required, application for provisional component certificate. These all are legal documents which you even can guide the student, or even your legal advisor, the LLB people will specifically guide you, or even with MA English. And if you do LLB degree is required, if you do LLB, you can very well go for English documentation. There is one. There are specific special there are specific the specific subject like patentability is there now in the semester 5 of LLB has been introduced. But okay, let's start for the new beginning. It may change your view. Rather, publishing submitting the thesis for PhD or MA in English, have some patent with that thesis, it will increase your weightage and also the quality. Now, my colleague, Dr. Dinesh Wanule sir, will guide you what is the legal aspect behind this patentability. Thank you, madam. Thank you.
Thank you so much, sir. Wonderfully presented. Thank you so much for your enlightening and comprehensive talk on IPR and patents. Sir, we are very delighted and at the same time astonished to know that you are a patentee of geography and Hindi languages, even being a researcher in sciences. Thank you, sir, for your valuable suggestions for the literature and language researchers, and we wish to seek your guidance during the process of publishing patents in a field. As it is clear now that the patent is one of the categories of IPR, the Indian Patent Act 1970 was enacted in 1972. Sorry, the Indian Patent Act of 1972 was enacted in 1972. It protects the rights of the patentee. The Act also provides guidance about patentable and non patentable investigations. To throw more light in this field, we have with us Dr. Dinesh Wanule as a resource person who will be sharing his ingenious views on the topic Patent Act 1970, focusing on the objectives of this Patent Act and the procedure for filing for patents under this particular law. To welcome and introduce Dr. Vanul, I invite Dr. Arina Nazneen, Assistant Professor in the Department of Languages. Over to you, ma'am.
Thanks much, Dr. Muslim, for giving me this opportunity. I am highly honored and feel privileged to have been given the opportunity to welcome our speaker for the guest lecture. On the behalf of the Department of Languages Integral University, I cordially welcome Dr. Dinesh Wanule to an online guest lecture on the topic Patent Act 1970 under the theme of the lecture Intellectual Property Right. Sir is a noted academician and has contributed richly to the growth and expansion of research areas. He is an assistant professor of zoology at Birla College of Arts, Science and Commerce, Kalyan, Maharashtra. Sir is MSc in zoology with first class degree, a specialization in entomology from Swami Ramanand Marathwada University. His doctoral thesis has been submitted to Swami Ramanand Tirth Maharashtra University, Nanded. On October 19, 2012, on the topic Studies on Insects as Source of Antimicrobial Agents. He has been bestowed with 8 years of teaching experience and 17 years of research experience. He is guiding the students' projects for BSc and MSc program at SRTMU University, Nanded from 2006 to 2008. His almost 20 research papers have been published in various national and international research journals. Sir has been awarded Rajiv Gandhi National Fellowship in 2007 from University Grand Commission, New Delhi. Sir's research field interest exhibits in entomology, insect-based medicines, environment, molecular biology, and microbiology. His today's session on the topic Patent Act 1970 will add a new spike to the academic discourse. So, without wasting time, I would like to invite Sir to escalate a new way of critical thinking. Welcome, Sir.
Thank you very much, madam. Am I audible?
Yes, sir, you are all audible.
Thank you very much, madam, for such a wonderful my introduction. Uh, Dr. Shahid Ali, sir, Dean of Faculty of Arts, Dr. H.M. Arif Nadvi, Head Department of Languages in Integral University, Coordinator Dr. Muslim Jahan. Thank you very much for inviting us for very important topic and we can say burning topic for the researchers as well as the I can say academicians filing patent, drafting patent, and get it granted. So this is a very important field for us nowadays. I will share my PPT.
Is it visible? Hello.
Yes, sir, it is visible. Yes, sir.
Yeah, thank you very much for confirmation. So, first of all, I would like to tell you that I am not a patent lawyer, or I am not from the field of the legal advice. I am a very simple researcher in the field of zoology, and I would like to file patents based on my research. When I found some novelty in my research, so we applied for the patents, and there is a process. I will explain that process meanwhile. So after getting the publication, one day we got mail from the controller of the patent that these many objections are there, and you have to answer these objections. So for that, then there are so many sections are there under these objections, and then we have to find out what is the exact meaning of these sections. And this interest bring me in this particular area of intellectual property right patent at 1970. So let us see what is the patent definition according to the government of India, as well as what is the international definition of the patent given by the World Intellectual Property Organization. That is, in short, it is WIPO. So in India, patent is a statutory right granted for invention to the inventor or his assignee. Assignee means the person who filed the application for patent. That person is known as the assignee. That particular invention is granted for the limited period of time and excluding others to make use of the invention. And we can sell that invention, or we can import the products required to do the patents. So this is an definition given by the Indian government, while the WIPO said the patent is an exclusive right granted for invention, which is a product or process that provides, in general, a new way of doing something, offering new technique solution to a problem. So, term invention, the then solving problem, such techniques are very important, which is having some industrial application, which is having commercial application. Such inventions can be patented, and the monopoly right must be given to the assignee or the patent applicants or patentee. And to protect their rights, this act is very, very important. Also, this act is very important while filing an application for patent, drafting patent, and giving answers if there are some objections against the claims made by us. So this act, as madam said, that this act is created in 1970, on the 19th September 1970. It was implemented in 1972. By 1970 to 1972, the various rules has to be designed, and these rules were published in 1972 for the intellectual property rights. So it is implemented in 1970. Before that also, Patent Act was there, but that was governed by the British government before the independence. So from the independence onward, Indian government thought about to protect the inventions and its utility. They have decided to create this particular act, and it was created on 19th September 1970. So this act is divided into 23 chapters. Of course, we are not going to discuss all those 24 chapters, because one lecture or even 1 week is not sufficient to discuss about these chapters. So important chapters which I found very important for the applicants. So these chapters we are going to discuss here, and it will help us for filing our invention. Now, chapter 1, that is related with the definitions. So, government and this entire team, the committee has defined various terms very lucidly and we can say very clearly, so that there may not be any conflict in the mind of the patentee or those who are taking the objections or even the government machinery. So this chapter, chapter 1, that is known as a preliminary chapter, which has many definitions related with the patents, intellectual properties. So patent is the any invention granted under this act. So when you file an application, that after that invention is granted, it will be called as patent. Okay. The patentee is a person. He may be natural person, or we can say he's an investigator. He can himself file the patent, or he can take a help of the patent agent, and he can file the patent application. Here this term patentee is very important for the investigators. Okay, if in the form number 2, if the name and signatures of the inventors are there and their names are not mentioned in the name of applicants, then they will lose this opportunity of getting patent. Okay, those who will file this invention, those are called as applicants, and patent will be granted to the applicants and not to the inventors. So those who are interested to file the patent, they must enroll their name in the list of investigator, inventors, as well as the applicant. That is a very important thing. Legally it is very important. Otherwise all rights that will be going to the applicant. So sometime it happen that the researchers, they are working in the R&D of any industry, so they are working that particularly for that firm and or the industry, so they applied the patent. So all rights are with the industry and not with the investigator. So we have to carefully uh, add our name in the list of the investors as well as the list of the patent. Then patent agent is an authorized person who know about the legal aspects, drafting and filing process, and sometime on behalf of you, he can give answers to the patent office. Then these three very important aspect, like section in the section, that is section 2J1, section 21JA and section 21I. So these are very important sections that define the patents. So patent is any invention which is having a industrial application. Okay, not all inventions can be patented. Not all inventions can be patented. Only those inventions can be patented which is having some industrial applications, commercial applications. So, and this act will protect our rights in the field of commerce. Okay, so section 21J that defines about the invention. So invention means a new product process involving inventive steps and capable of industrial application. Okay, patent novelty is very important. If your invention is not novel or it is already known, so such applications are rejected by the Indian Patent Office. Then second, section that is very important again, section 21JA. Section 21JA defines that inventive steps. So when you draft your patent, that the process, if you are filing or patenting, that process must have some step. And if it is a product, how the product is formed, that you have to describe in a stepwise manner. Okay, so we have to prepare a protocol for the patenting. If it is lacking any patent, any application lacking these steps or inventive steps, then there may be a question on by the controller of examiner that the your patent application is not fulfilling the section 21JA. So that means there is a need to update or amend our application, so that we have to introduce the inventive steps. Then new invention, that is come under the section 21I. So new invention, it has not been published already in the public. Okay, so though it is published, within the 6 month you have to file the patent if you have exhibited in somewhere. So that you have to file within the 6 month. So instead of that, I will suggest that whatever your invention is, that you file first for the patent, and then you can publicize. Then the chapter 2, it discuss about the section what is invention not patentable. So we have seen what can be patentable. Novelty must be there, industrial applications must be there, and inventive steps must be there. Okay, so now these three criteria, if they are fulfilling, there are some criteria under which your patent may be rejected. So for that, we must know what inventions cannot be patented. So this is disclosed in the chapter number 2 of the Act, that is section 3. So section 3 discuss about the invention non-patentable. This is again very important, so that initial stages we can understand whether my invention is patentable or not. Okay, so on our basis only we can understand whether it is whether it can be applied or it can be granted or not. Okay, before you are taking help or assistance of the patent agent, because patent agents also charge lots of fees for that, for the consultancy charges. For every step they have their charges, and we may lost lots of money in that. So instead of that, if we learn what can be patented and what cannot be patented, then we can take decision of whether we have to file our application or not. So section 3 discuss section 3A discuss about the frivolous applications, or which are the obvious things. So if the particular invention fall in the category of obvious things, which has to happen naturally, your invention may be based on the natural law. For example, the gravitational force. Now when the pen we release from air, it will go down, it will reach to the ground. So that is natural phenomena, we know that. Okay, so this has to be happen very obviously. So such invention cannot be patented under the section 3A. Then next, section 3B, that is the it is contrary to the public order or the morality. So any invention which is cause damage to the society or animals or plants or environment, So such invention, though the invention may be new, but it is causing harm to the public, it is causing harm to the morality of society, or it is causing damage to the biodiversity. So such applications will be rejected, such inventions will be rejected by the patent authority. Then section 3 C that discuss mere discovery of the scientific principle. So which are known, those inventions are known. Just you are making a admixture of those uh, two inventions together and putting them into one draft and filing. Okay, or which discoveries are not very significant in the way that useful for commercial or industrial purpose. So such things are called as a mere discoveries of a scientific principle, and that can be again non-patented. Then section 3D, the mere discovery of a new form of known substance. Okay, so substance is already known, and you have discovered the substance again by another process. So such things can also not be patented. That will be considered the mere discovery of the new product. So, for example, this pen. Now, pen it has been it had been invested in past. So you have uh, find out a new method of making pen. So that cannot be patented. It will be considered as a mere discovery of a new form. So pen is already discovered. Okay, so in the chapter 2 section 3E that suggests about the mere admixture that cannot be patented. Now I have given one photograph here that you can see lots of ingredients are placed. Now suppose the ingredient A, B, C and D, these ingredients they have the same property of healing, and I am mixing these A B together, and I am claiming that that particular mixture is useful for the treatment of a particular disease. Then government will say that no, all these substances are known for curing the same disease. So you are just mixing this together and you are claiming about the patent. So such admixture of the different, we can say, ingredients, chemicals together and producing them into a new product cannot be considered for patent. So this will be considered as mere admixture of the chemical. Then section 3F that is a related with the arrangement and rearrangement and duplication of a device. Okay, so this also is not allowed in the patent. Okay, a chair with the handle at a particular height, and if you want to make some changes, you can increase the height or increase the width of the handle, and you apply for the patent. Government and controller of patent, they are going to say no, no, this is just a rearrangement of a known device. It is just a mere rearrangement or duplication of a known product. So it is not allowed. Okay. So I will tell you how this can be used, how we can do apply for patent arrangement and rearrangement particularly. See, patent can be applied in two forms. One that is, as sir said, utility patent, and another is a design patent. So you can file application for utility, or you can file a application for design. So you can see here there are two types of silencers. Okay, silencer is known that having a catalytic converter, that absorb most of the greenhouse gases and reduce the greenhouse gases to emit into the environment. So these property is already known. This utility is already known. So we cannot file the application for patent of silencer. Then how we can apply? We can apply for the application of patent in design. We can apply for the design. So here you can see these are exhaust pipe. They are more or less they are a square, and here you can see it is a round or circular. They are circular, cylindrical shape. So there is a difference between the design of both the silencers. So definitely we can file patent in the design. Then next is section 3H, that is related with the agriculture and horticulture. No method of agriculture and horticulture can be patented because this is very essential for the survival of humankind. So the agriculture and horticulture processes cannot be patented under the section 3 of the chapter 1970 Act. So any process for medicine as well as the surgical, curative, prophylactic, diagnostic and therapeutic cannot also be patented. Okay, if these medicines or surgical or curative, diagnostic, therapeutic things, they are filed patent, then cost of surgery, cost of medicines, that will increase hundreds of time, and then it cannot be accessible to the poor people. So government of India 1970 itself decided not to give patent for such invention those are involved in the field of medical, in the field of pharmaceutical. So medicines and surgical or curative or prophylactic diagnostic stage procedures, they cannot be patented. But of course the product may be patented. Then section 3J also, that is plants and animals, that cannot be patented. Animals and plants, they cannot be patented because they are existing on earth uh, from very beginning. They are natural one, and hence they cannot be patented. Though the in the particular biodiversity scientist or taxonomist, he found that animal first time, discovered first time, still it cannot be patented. But very early 1970, government has given right for patenting microorganism, because these microorganisms having a very commercial importance in for example curd making, paneer making, they are utilized, these microorganisms are utilized, though they are present in past. Using the genetic engineering, we can modify these microorganisms. Their genetic makeup can be modified, and their we can say the hybrid varieties can be produced, which can enhance the productivity. So, considering this, government has given right of patenting microorganism. Nowadays, according to 2001 amendment in the Patent Act, we can we can register the plant varieties. As such, we cannot file the patent on plant, but newly produced plant varieties, that can be allowed to registered by the government of India under the intellectual property. Okay, so section 3J that discuss about the plants and animals cannot be patented, of course, microorganism can be patented, and amendment in Patent Act 2001 that suggests that yes, of course, we can register the plant varieties. Okay. Then mathematical expressions, business methods, computer program, they cannot be patented in India. Of course, in some of the countries, the uh, computer programs can be patented, but here in India, computer program cannot be patented. Now, mathematical expressions are there, business methods are there. That is also a intellectual property. Computer program is a intellectual property. Then we how we can protect our this intellectual property. So government has created a copyright act. Okay, so stories are there, or the poems are there, dramas are there, music compositions are there, artistic works are there. These all intellectual properties can be protected using copyright. And sir has told you that the copyright has a longer lifetime. Okay, that is up to the survival of the author, and after that, even after that, next 60 years the copyright will be given to the assignee. You can gift your copyright to uh, maybe your beloved one, and after the death of the author, that right will be given to the that assignee. So this is an very important thing, and copyright protects our these types of intellectual rights: literary, dramatic, musical, artistic, aesthetic, creative things. Television serials are there. These all these can be copyrighted. They cannot be, though there are some importance in the industry, uh, they cannot be patented, but of course they can be protected from making its use by others using the copyright. So this is very useful for the language people, copywriting. And for copywriting, you on your own you can do. It is a very simple one, and the charges for copywriting are also very less. For every copyright you require to pay around 500 rupees, and it is universal one. That is again very important. Your copyright is a universal, its protection is universal, while the patents protection, that is a territorial right. Patent protection is territorial, where you applied for the patent, only the protection will be given in that particular country and not in any other country. So that is a one, we can say, a drawback of patent. Okay, because it has not been taken by the WIPO. That issue has to be taken by WIPO, and even today the patenting can be done universal. Okay, so patent is a territorial right. If you applied in India, your invention will be protected in India. No other person can make use of your invention, cannot make use in industry, cannot duplicate it. But outside of the India, the other countries, that they can make use of your invention, they can produce the goods using your process, patented process, because we have not applied in that country. If you are seeking protection of your invention in other country, so you have to apply a separate application in that country. So before that, you have to apply in India. Before you are applying a patent, your invention for patent, that you have to apply first in India, and then you can apply through World Intellectual Property Right in different country. Okay, so this is about this particularly copyright and the patent act. Then you can see the Section 3M, mere scheme, rules or methods or games, they cannot be patented. Okay. So any new game, any new rule, it cannot be patented. That will go, if it is a new game, the design of that game, of course, can be patented, and not the particular game. Then presentations, as you are watching my presentation cannot, however it may be new, it cannot be patented. It will come under the other intellectual property, that is copyright. Then topology cannot be patented. The section 4 is very important again. Section 4 said that any invention related with the atomic energy, that cannot be patented, though it is very important, though the invention is very novel, has an industrial application, whatever it may be, it will be rejected under the section 4, because it is violating the section 4 as atomic energy not patentable. Then chapter 3, that discuss about the application of patent. So those who are seeking protection of their invention, they have to apply a patent in there are important forms. I can list out these forms later, that you have to apply in a prescribed format or the legal format, and this right is given under this particular topic. So you have to apply your invention for patenting. Then section 7, that tell about the form of applications. Section 8, that discuss about the information and undertaking regarding the foreign application. So this undertaking you have to give to the patent office, that you have not applied this particular invention in any other country, or whether you have applied in any other country. So here you have to given in undertaking whether this application is already this invention is already applied in any other country or not, any foreign country or not, that you have to give in writing in the beginning. But I will suggest you can do that. You can file your patent outside the India first, and then you can file in India. You can do that, but I will suggest that you file the patent application in India first. That will be more useful, we can say. Then patent form number 2, we have to write patent in a particular format given by the controller of patent. So what it include, the structure of patent is like this. The title of patent, so your invention, you have to give some title, and that title must be brief, very we can say very short one, and it will be reflecting the invention. So in such a way that you have to write title. The next thing that you have to write, the field of invention related, whether it is related with the entomology or in endocrinology or any other subject. So that field of invention you have to discuss. For say it may be related with the languages, so you can write the particular invention is in related with the languages, or a Hindi language or particular English language. So that field of invention you have to disclose. Then the background art, or it is also known as the prior art. Now prior art means what we do in the research, that is a literature survey. Okay, here in the term of the Patent Act, it is known as the prior art or the background art. So we have to write about the literature, what you have studied, and where are the gaps in the invention, and how you have bridged those gaps. So that will be helpful to understand that to the examiner that there are lacunae in some inventions, and these inventions are fulfilled by this particular patent. So prior art is another word is a literature survey, you can say. Then statement of objective and invention. So you have to write objectives 1, 2, 3. Why you want patent, and what are the importance or significance? Why you have conducted this study invention, that you have to write in a objective. Then statement of invention. So you have to write about the statement, one statement about the invention. Then list of drawings. So particularly we people in science, now we have lots of drawings, then sections of the animal tissues that we can put in support of our patent. So these there should be a list of drawings and the drawings that we have to submit. Then specific description. So you have to describe your invention. Here, don't uh, hide anything. Okay, this is very important. No, you have to write in a lucid manner so that the examiner can understand what is this particular invention, what are the steps involved in the invention, and what is the output. To know that, we have to write in a lucid manner, so that sometimes the patent examiner may be from a different field, particularly in the biology field. We are from biology or we are from zoology, and the application went to the chemical engineer or the person from the medical field, MBBS field. Then examiner may not be knowing much of the ours terminology, and he may not understand our important invention. So you have to write in a very lucid manner. You have to disclose all the steps which are involved in the invention. You have to you have to tell about your product. Then finally, the claims you have to write. Claims, what particular things you would like to protect. These are your claims. So while writing claim, we have to be very careful for what purpose we would like or we are seeking protection. Those things you write down clearly in claims. So claims can be written 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And these claims we would like to protect from making its use by others. Okay, so examiner will see all those claims, and he will make his decision. So, then abstract, a small summary at the end you write about your invention, and the drawings. If drawings are involved, you can put those drawings or figures you can put at the end. So this is a particular structure of patent. In this particular manner or the pattern, we have to file application. This is under the form 2. So form 2 we have to write this. Then chapter 3, that discuss about the application of patent. So there are two types of applications of patent. One is a provisional, and second application type is a complete specification. So provisional applications, suppose you have idea in your mind and you need some time to execute your idea. You are not reached to a particular process, end of the process, or the end of the that particular product. You require some time. But meanwhile, you thought your invention may be still by some other person. No, already Nagare sir told you that if patent agent is faithful, then only you discuss with him, then only you discuss all the process with him. Initially, when we go through the patent agent, that time we also be very careful, because your invention may be stolen by that patent agent. It is possible, and he may sell it to another person. Now, in patenting, it is very important. Time is very important. The patent will be granted by the government, who will file that patent application first in the patent office. Suppose there are two colleagues. I am working on a particular invention, but the other colleague, he come to know that this is a very important invention, it is having novelty and industrial application, so he will steal my data, and he will file the patent application in court, sorry, in the patent office. And later on, after completion of my invention, I went to the patent office and I filed. The patent authority will not grant patent to me, because it is already filed by my colleague. So we have to be very careful about our invention. The secrecy of invention is very important in this case. Okay, so don't disclose your idea to others. And if you have idea and you want to protect, government has given uh, good option that we can file the application of provisional. So I have idea, I need some time to incubate my idea, to finalize it to the product. What I can do, I file one application, patent application, known as a provisional application. So that idea will be protected under my name. So it will be protected, and nobody can make use of that idea further. Okay, so it is just like first come first serve. So I have applied. Then government give me a 12-month of period of time to provide a complete specification. So within the 12 month, I can work on my idea. I will bring that idea to final stage, and then after that, I can file another application known as a complete specification. So here you are disclose all the things. Okay, so these are the two types of the application. One, that is a provisional application, another is a complete application. So provisional application protects your idea for 12 months, not beyond the 12 month. Okay, so within the 12 month, you have to file the second application, that is a complete specification. And then the actual patenting process that will be executed. Okay, so this is another very important section under the chapter 3, that is section 9. Okay, then section 10. Now I will take a little more time. Provisional. So when you file provisional application and after 12 months you are not able to file the complete specification, that means you cannot be given a patent granted. Okay, patent cannot be granted. Just filing provisional cannot be considered that patent is granted. Patent can be granted only filing the complete specification. Another thing I want to clear, that there is a no need to do the always provisional application. If your idea, you have a developed a entire process, or you have a final product in your hand, definitely you directly file the complete specification under section 9 of this patent act. Then section 10, that is the contents of specification. So this initially provisional, you can give some idea about the patent. No need to disclose entirely. Just you give a brief idea about your process or product that you want to patent. Okay, but in the complete specification you have to disclose it completely. Okay, then chapter 4, that related with the publication and examination. So you have to file the form for publication of your invention. So as like the our research paper, they are published under certain journals. So government also published one journal called journal, official journal of patents. Official journal of patents. Inside this official journal, new inventions are published. New inventions or the applications for patent, they are published. Okay, so that takes place around 18 months. So after filing a form for publication, that that particular invention will be published in the journal. Okay, but that will take around 18 months of time. After 18 months it will become public, and if any person would like to take objection, he can put his objection in front of the controller of examiners. Okay, so that for that publication is very very important. So we have to file the form of publication. The next, that is file the form of examination. So we have to file a one particular form for examination. Then and then only the controller of patent, he can assign the examiner. Without filing this form for or the request for examination, that is under section 11b of chapter 4, your patent cannot be granted. Okay, so we have to appear for the examination by filing this request form for examination. Then controller will assign examiners for your invention, for your application. So that will take around a 48 month from the date of filing. That examiner can give his remarks, can uh, tell about whether the invention, it is a novel, it has a industrial applications, it can be patentable or it cannot be patentable. So such results can be given by the examiner to the controller of examiners. Okay, so controller or examiner who looks all the process about the patent filing, publication, assigning the examiners, appointing the examiners, and taking results from the examiners, and revert back that result to the inventor or applicants. More specifically, it will be sent to the applicant, we can say, instead of the inventor. So after that examination, if everything files well, there are no objections, then patent can be directly granted to the applicant. If there are certain uh, observations made by the examiner, or some contradictions are there, like section 2(1)(j) or section 2(1)(ja), lack of novelty, okay, lack of inventive steps, then that controller can ask justification for that. So you have to come in front of the controller of the examiner, controller of the patent, and you have to explain that entire process or the product, their novelty, their applications, that you have to tell to the examiner in hiring. So virtual hirings, virtual hearings are done for such type of things. And after hearing, the virtual hearing, that controller can take decision whether the patent can be accepted and granted, or it may be rejected, or amendment has to be done in the patent. So he will guide about that under this particular act. Then I told about this chapter number 8, grant of patent. So patent will be granted if it is a novel, it has an industrial application, and inventive steps are there, then it can be granted to the applicants under this section 43. Then the what are the rights of the patentee? That these are rights are disclosed in the section 48 of chapter 8. So we can protect our invention of making use by third party. Any other person cannot make use my invention for commercial purpose, and if he is doing, then we can stop him using this particular act. So there are provisions for preventing third parties of making use of your invention. So there are remedies are given in this particular act if someone is doing illegal such illegal act, stealing your invention, utilizing it for the commercialization. So we can prevent that using the using our rights. Then what are the other benefits? I can make use of my invention, as this is a monopoly right, my right. I can sell my invention to industry. Now sir has told that he has sold many invention to the industry, and in return industry can pay me a royalty. So I can decide how much royalty I would like to take. So it is a good source of income. Okay, patent is basically done for that only, to make the invention commercial. So it is a commercial aspect. Then those product you need to import from other countries, that permission is also given to the patentee under this particular act. Then chapter 9 that discuss about the patent of addition. So when you filed the application, and maybe after filing you have carried out your work, and you found that there are, we can reduce 2 3 more steps from the entire process, so that the process can be speed up, the product find will be more finished product. Now in such cases, you can not you need not to file the application again, just you have to file the patents of addition. So that additional part you can amend it in your patent, okay, already filed application, so that whatever the time which has lapsed meanwhile, that can be protected. Okay, so these are the important chapters under the 1970 act. These are the very important sections: patentability, non-patentability, filing an application, publication, examination, request for examination, then grant, what are your rights. Okay, so that one inventor must know. Okay, so these are some of the points we have covered. Now you people, you are belong to the language department. Now how you can apply for patent? Patent is mostly applied by the science people, medical people, okay, for their new inventions, technology, engineering. So how we can involve in this process? There are two ways that Nagre sir also told about you, that you can help in drafting the patent. You can help in designing that particular product. So they you can apply for design patent. Utility, of course, it is very difficult for the people from the language department, but of course that can also be done. But when we have collaborations with these people, you can see here we can solve that puzzle by joining hand together. So collaborations are important. Language people, they can help the science people or engineering people in many ways. So collaborations are very important. Support is important. Patent filing, it can be done in a teamwork, joining 2 3 departments together. Okay. So when we have trust, we are motivated, we are inspired, then only we can achieve this. Now I will give one example. Now, language translators. Nowadays, these can be their designs can be patented, or if we join our hand with the engineers and help them in this particular area of language translation. Yes. So such devices we can prepare with these engineer people. They are they are not knowing about the different terminologies used in in the languages. So we can help them to create. So this is one example. Another example, dictionaries. This can be put into the instrument, and that can be patented. Instrument can be patented as a product, okay, or it can be patented as design. Then of course you can help in the patent drafting, okay, so that in a systematic way we can draft that patent and we can help it file. If we take some of the sorry some more knowledge in this field, we can give a consultancy to those researchers. So these are the various areas. Definitely, we can help in filing patent. Language people, particularly, they may help in filing the patent. Okay, so I would like to finish here. I hope I have finished within the permitted time, and I am very much thankful to the authorities of the Integral University. I am also thankful to our management, our principal sir, who permit me to give this lecture. Thank you very much. Thank you, Muslim ma'am.
Thank you, sir, for your extremely beneficial ideas about Patent Act 1970, which we all are sure to apply in your future ventures. Sir, you have explained the procedure of filing patents in detail without leaving room for any further doubt regarding patents. Considering in mind the requirements of literature and language researchers, you have explained us very effectively how can any literary, artistic, or musical work could be a patent. Now it's time for question answer session. I request the participants to type their questions in the chat box. Waiting for your questions, dear participants. I think there isn't any question because the presentation are already very elaborative. Now I'd like to extend an invitation to Dr. Hafiz Muhammad Arif, Head of the Department of Languages, to present a vote of thanks.
So, a very gracious good afternoon to all of you. This is Dr. H.M. Arif, heading the Department of Languages, initially serving the Department of Languages, representing, hello, hello,
Audible, sir. Audible.
Audible, sir.
yeah,
Sound
okay,
good.
okay, okay, representing the Department of Languages, Integral University, Lucknow. So, Lucknow is in itself a city of multiculturalism. Shahre Nigara, city of civilization, culture, and Nawabs. It is known Awadh, city of Awadh, and having a historic background, cultural background, especially in Urdu background. That's why I would like to recite one couplet in Urdu. It is very significant. किया तबाह तो दिल्ली ने बहुत बिस्मिल किया तबाह तो दिल्ली ने भी बहुत बिस्मिल मगर खुदा की कसम लखनऊ ने लूट लिया सो
Yeah.
दिस इज किया तबाह तो दिल्ली ने भी बहुत बिस्मिल मगर खुदा की कसम लखनऊ ने लूट लिया सो dear participants, honored to get an opportunity to propose really a hearty vote of thanks, especially, very especially to our expert speakers. Really, you have expertise. Whatever you are delivering, really worthy listening to. And thanks for the time you spared from your hectic schedule to grace the occasion. Really a historic and memorable event. Thanks for your scholarly comment, as they are essential to nurture creativity and the ability to innovate from a young age, rather throughout the academic and research career. So, hardly do I have words to express a sense of appreciation for you. Accept my humble words, sir, accept my humble words representing the Department of Languages, faculty members of the department. And congratulations to Dr. Mursaleen Jahan for successfully coordinating and making it an very easy access to all participants. In the meantime, who will forget the contribution of my faculty members of the department? So thanks to all faculty members who are actually the pillars of the department, who supported us in all ways. Thank you again. Thank you very much for sparing your precious time for the department, especially, and for the participants generally. Thank you very much.
Thank you, sir. Thank you very much.
Thank you, sir. Thank you.
Thank you. Thanks.
We hope for further cooperation. मैडम आपका माइक बंद है. Now you are audible.
Thank you, sir. I hope that all the participants have gained a sufficient understanding of intellectual property rights and researchers are sure to utilize this knowledge to find prospects of patents in the field of arts and humanities, which is indeed a neglected field in terms of intellectual property rights, especially in the form of patents. I just wish to share that we are sure to find something positive in the midst of adversity if we keep an optimistic attitude. Despite the numerous bad consequences of pandemic and lockdown, which we even don't want to recall, it does provide us with an idea of virtual gathering, a blessing in disguise. Now, what a simple task it has become to host a lecture via an online platform. How difficult it would have been for speakers to travel nearly 1,447 kilometers to Lucknow to provide a face to face talk. Be optimistic, be happy. I once again thank you all for you have squeezed this event into your already hectic schedule. Thank you, sir, so much for your time and patience.
Thank you.
Thank
Thank
you,
you
madam.
very much,
Thank you very
madam.
much, madam.
Whenever you come Mumbai, please come here, BK Birla
For
College.
sure, sir. Sure, sir.
We will also come there, Lucknow.
Yes, sir, you're most welcome here in Lucknow.
Thank you.
Thank you so much.